Hey landlords, did you miss the deadline for AB 1482? We just released an update video on the Tenant Protection Act of 2019, also known as AB 1482, and in that guide for renters and landlords, we ran through AB 1482 and we promised to share what happens if you had missed the deadline. Well, based on the comments in that video, we didn't do a very good job of explaining exactly what the deadlines are built into AB 1482. So we are back and we are actually going to hopefully do a better job explaining. We have an infographic to lay it out and lay out the timeline. So this is a guide for renters and landlords to the deadlines in AB 1482. Hey there, Christian Walsh, real estate agent with Wire Associates. We've been helping renters and landlords understand and make the best decisions in this crazy market. Two important things you may have heard me say before. Number one is we can't give tax or legal advice, but for the most honest and up-to-date real estate advice, subscribe to this channel. And two, don't forget that you have to understand your local legislation. Some areas have legislation for rent cap and just cause evictions that supersedes AB 1482. So make sure you talk to an attorney so that you understand exactly what your rights are as a renter or landlord. First, we're going to run through the civil code quickly, and then we're going to dive into an infographic that explains how the timelines and deadlines work. So if you're ready to understand the deadlines in AB 1482, hit that like button and let's get started. The start date of the tenancy is what matters to AB 1482. So for an exempt property, if the tenancy was in existence before July 1st, 2020, the notice under the law could potentially be in the rental agreement, but it's not required. And if it was commenced or renewed after July 1st, it must be in the rental agreement. We're going to show you an infographic to explain exactly how this timing works. And then here's the language for a property that's subject to AB 1482. Again, July 1st, 2020 is important. So they flip things around in here. So any tenancy commenced or renewed on July 1st, 2020, it can be given as an addendum to the lease or rental agreement, but it must be signed by the tenant. And this is, again, a property that's subject to AB 1482. If the tenancy existed before July 1st, 2022, the written notice must be given to the tenant by August 1st, 2020. So that is the deadline, and it only applied to properties that were subject to AB 1482. We're going to show you on the infographic now really how this lays out. There's a lot going on in this infographic. Don't be scared. We're going to run through real fast. And I feel like this will help explain what we mean by the AB 1482 deadline. And I have deadline in quotes, and that's because there really is only one deadline that's written into the language, and I'll show you that in a minute here. We already covered it when we dove into the civil code. Let's take a quick look at our key here. So the red line will be the tenancy existing before July 1st, 2020. We're just using the language from the bill. That's why it's in quotations. Then the blue line is tenancy commenced or renewed on or after July 1st, 2020. And I'll explain why that's important. And then the star is the deadline or the start date. So that's a better way maybe to look at it. Is AB 1482 really only has one deadline. It has other start dates. We've got the dates on the infographic. So January 1st, 2020 is technically when the bill went into place. 7/1 was an important time period for the bill, and I'll explain that. 8/1 is a deadline, and it's still going on. So this bill is still in place. It's going to be in place for a total of 10 years, and it may be extended, it may be changed. And speaking of changes, part of the reason we're here to explain the deadlines is the language in the bill was fine-tuned. The first version that was passed was sloppy, for lack of a better term. There were mistakes in there, so it was fine-tuned. And that's why, in addition to the pandemic and the fact that it was rolled out the way it was, that's why there's so much confusion. And you'll find that even attorneys disagree. But we're going to dive in and see exactly what it says. So let's start with the exempt properties. And this would be specifically single-family condos, owner-occupied duplexes. That's the short list. There's others, but we're going to just deal with that list right now. So if we look at those that had a tenancy existing before July 1st, 2020, that red line, you can see that actually there isn't a start date there. So why is there no star on this line? Well, there was no deadline written into the bill for landlords who were exempt to give the language to their tenants. And that was one of the things in the beginning. It made it look like all tenants, whether they were exempt or not, had that August 1st deadline. And we'll explain when the August 1st deadline played in, but it did not play into exempt properties. So technically, if the tenancy started before July 1st, 2020, a landlord may not have given the exemption notice yet. Now, here's what's important. The landlord doesn't have the exemption for AB 1482 until that exemption form is given to the tenant. So that's an important point. Before a landlord does a rent increase or attempts to do a just cause termination of tenancy, the landlord should give the exemption language. Now, there is a group that may have lost their exemption, and I'm about to explain. And if we look at the next line, so this would be a tenancy that either started or renewed on 7/1/2020 or later. So this would be somebody who the tenant moved in after that date, or the landlord gave a new lease to a tenant who was there before that date. Now, what it says specifically in the bill, that in this case, it must be in the rental agreement. The exemption language must be in the rental agreement. So that is a start date right there, and that's why we have a star on it. So any tenancy that started after 7/1/2020 for residential properties where their property is exempt, the landlord needed to give the exemption notice when signing the lease. If a landlord did not give the exemption language for a tenant who moved in after July 1st of 2020, then that landlord may have lost their exemption. So that's where it would be very important for a landlord to reach out to an attorney to discuss the situation. So hopefully you can see the difference there. So if a landlord had a tenant before July 1st and just decides today to give the exemption notice, technically they can. But if a landlord had a tenant move in after July 1st, 2020, or renewed the tenant who's from before then, renewed their lease and gave them a new lease, if they didn't include the exemption language, they probably can't put the exemption on the property now. So that's an important point, and that is a group that potentially lost their exemption status for their property. Okay, so below that we have properties that are exempt because they're 15 years or newer. Now remember, that's built into the bill, and what it says is if a certificate of occupancy was issued and the property is under 15 years old, it rolls. So as the property gets older, once it crosses 15 years, it will be subject to potentially to AB 1482, and that would be any non-owner occupied duplex or bigger. So a building could have 100 units in it, and as long as it's younger than 15 years old, it will not be subject to, none of those units will be subject to AB 1482. Now, one attorney out there that I know, and I haven't talked to others about it, but I know at least one, says that that case, the landlord does not have to deliver exemption language if you're within the period, that 15-year or newer period. My advice is that a landlord should just go ahead and deliver that form. And obviously, once you cross over the 15-year threshold, the landlord should then change it to get rid of that exemption. But I think it's a best practice to just go ahead and deliver that form. All right, so moving on to the properties that are subject to AB 1482. Again, non-owner occupied duplexes and larger would be subject to AB 1482, except for a very few limited circumstances where they wouldn't. We won't go into that now. But we flop things here, so we've got now the blue line over the red line. And the reason that is because the bill language flipped. I showed you that real quickly. So I just wanted to point that out, why I flopped that. So if the tenancy commenced or was renewed on or after July 1st, 2020, it didn't have to be in the lease. It could be an addendum to the lease or rental agreement, or as a written notice, but it has to be signed by the tenant. It also has to be at least 12-point font size, so the tenant knows their rights under AB 1482. And that started on July 1st, 2020. Anybody who is signing a lease or who is renewing a lease should be also signing this form as well. Here's where it gets interesting, and this is where the deadline of August 1st was built into the bill, and that was for tenancies that existed before July 1st of 2020. the landlord was supposed to give a written notice no later than August 1st, 2020, as an addendum to the lease or rental agreement. So if a landlord missed that, there's no teeth to the bill and nothing, no penalty necessarily for the landlord, but it is imperative that the landlord gives that. And the property is subject to AB 1482, whether or not that's given, but it's important the landlord actually give that. So I hope that clears things up. That is the August 1st deadline. It was for properties that were subject to AB 1482 who had tenants before July 1st of 2020. If you'd like to take a closer look at the infographic from this video, our email newsletter subscribers are going to get a copy of it. So make sure you sign up below to receive our free weekly email newsletter. Leave your AB 1482 questions below. Hopefully we did a better job this time of explaining AB 1482 and the deadlines. And let us know what other topics you'd like covered for renters and landlords in this crazy state of California. And if you missed part 1 of this video, make sure you check it out because we do a pretty good job of explaining the other sections of AB 1482. Thanks for tuning in. This has been Christian Walsh, real estate agent with Wire Associates, and we want to hear from you.